My name is Oliver Westmoreland. I am an OSC registered Level 3 immigration advisor and I'm a consultant with GSN Immigration. Please subscribe to our YouTube channel and click on the bell icon so you can continue to watch our extremely interesting videos about UK visa and immigration advice. Today's topic is the rather unpleasant and difficult subject of grounds for refusal. What is grounds for refusal? Grounds for refusal is a scheme or a system, or part of the immigration rules in fact, whereby the UKVI or the Home Office can refuse your visa application, but not for standard reasons, not because you didn't have enough money in your bank account on a particular day, not because you didn't provide sufficient evidence that a relationship was genuine, for other reasons, more sort of dodgy reasons. For example, criminality, criminal convictions, deception in a visa application, overstaying, breach of immigration conditions, bad stuff like that. This is what grounds for refusal is about. Do you understand this basic, very important thing? Grounds for refusal can be exercised in connection with the application, the current application. They can also be exercised on the grounds of historical bad stuff. And the scheme is quite complex, but that's something you need to be aware about. Well, if you're involved in this sort of thing, it can relate to the current application. It can relate to history. The strange and interesting thing about these rules, or one of them anyway, some types of visa applicant are much more thoroughly punished by these rules than others. Sounds a bit strange, but this is the way it is. For example, somebody who applies for a family visa under Appendix FM, they can be punished by the rules, but not as much as some other people. That they can be engaged by the rules or get caught by the rules, but not so much as some other people. People applying under the EU settlement scheme, these rules don't touch them, strangely enough. Doesn't mean to say that you can be a mass murderer, but the grounds for refusal rules do not touch those who are applying under the EU settlement scheme. On the other hand, people who are applying for study visas, work visas, all the rules apply to them. They can get caught by all the rules. So the scheme is really very differential. And if you're a person or you know somebody who you think might be caught by these rules, you probably want to take expert advice, because the rules about this, the rules about which rule engages which type of visa applicant, it is complex, and you might need some good advice about this. Another thing that you need to be aware about, well, some people do, if you are deemed to have done something bad historically, as I said, these rules can be about historical events. If someone is deemed to have done something bad historically, they can face a time period ban before they can make another successful visa application. In some dreadful cases, the ban can be as long as 10 years. So these rules have got quite strong powers. I think I'm going to struggle to explain these rules to you in this video because they're so complex. I have a better idea. I will give you some examples of how the rules operate. You or your friend, you want to apply for entry clearance as a student, but you recently served, your friend recently served a 15-month prison sentence. This person would be caught by grounds of refusal and the application would be refused, mandatorily refused. No way round it, no way out of it. Another scenario, your friend wants to apply for entry clearance as a spouse, for a spouse visa. They recently served this 15-month prison sentence. They wouldn't be caught by some of the rules, but they would be caught by other rules. And this is an area of complexity that I wanted to spring it on you at the wrong moment. Sometimes the applicant gets caught by one part of the rules and not the other part. As I say, the scheme really is quite complicated. This friend of yours who's applying for a spouse visa who served a 15-month prison sentence, their application is necessarily going to be unsuccessful unless 10 years has passed since the end of the sentence. So these rules have this complexity as well, another type of period of time ban relating to criminal convictions. Let's take another scenario. Your friend wants to apply for entry clearance as a skilled worker. They very recently overstayed for about 6 months when they were last in the UK. They will get caught by the rule. Their application will be necessarily refused. Another friend of yours, you've got so many obviously, is applying for entry clearance as a spouse. Similarly, they very recently overstayed by 6 months last time in the UK. Now, their situation is a lot better, is a lot more favourable. They would not be caught by the rule, and unless the Home Office tried to use some really big rule, like that their presence in the UK would not be conducive to the public good, which is probably unlikely because overstaying is not the most serious offence. Most likely, such an applicant would not be refused. Their application would be, if everything else was good, their application would be successful. Now, I know I've presented more questions and answers probably to some extent. I'm sure that Mr. Shah will have some interesting questions so we can unpick some of this.
Sure, thank you so much for elaborating on this area. And lots of people who are applying for UK visa are usually worried about the reason their visa might be refused for. It would be good for them to know this information and plan their applications better.
Yes, if you know if it's definitely the case that you're going to be refused, it's going to be a supreme waste of time, effort and money to make the application at all.
Exactly, and it might be worth taking advice before making the application.
I would say definitely, and competent advice as well.
Brilliant.
Not from your local greengrocer, but from a qualified immigration advisor or lawyer.
Exactly. All right. We have a query from a gentleman who said he's been rejected a visitor visa in the past based on deception. He said some of the bank statements he submitted, the Home Office said they were not genuine. And he's saying he is now married to a British lady and he's applying for a spousal visa. Will that refusal based on deception for visitor visa still haunt him with this application?
Good question. Because of the obscure and complex way that these rules work, your client or your friend will be pleased to know that he won't be caught by this because he's applying for a spouse visa. As I say, family visa applications, they escape from a lot of the rules. He will escape on this occasion, so his visa application should not be refused for this reason.
That's great. That's such a relief for the gentleman. We have a few other queries as well, and I'll put them across you. So there is a gentleman, he said, I was refused a Canada visitor visa, saying they do not believe that my intentions are genuine to visit Canada and I will return to my home country.
Sorry, I didn't get that. I will return to my home country.
So the Canada embassy, when they refused the gentleman's visa, they said, we do not believe your intentions to visit Canada are genuine, and we don't think you will return
I see. Yes, understand.
After you come to Canada.
Yes.
He said, does that affect my UK visitor visa application because Canada said my intentions are not genuine?
I don't think it will, to be quite honest with you. The Canadian authorities can think what they think. I don't really think so, to be honest with you.
Brilliant.
I mean, if he had 10 visa refusals from Canada, I suppose it might, but I think one, it just wouldn't be significant.
Great. There is a student, and he's put across a question. He said his student visa for Germany was rejected, and I don't want to declare it on my UK student visa application. Can this become a reason for rejection that I'm not declaring my past refusal?
What do you mean? He wants to make an application and not declare that?
Exactly.
And is he a client of yours?
No, it's just a question.
Because if you supported that, you'd be breaking the law, Mr. Shah. I'm sure that you wouldn't do that.
Exactly.
Look, in the immigration business, we cannot advise clients to act dishonestly. Concealment is an act of dishonesty. We can't advise people to do that. Maybe he would never be caught, but we can't advise people in that sort of way. We advise people, if you want to follow our advice, you have to act honestly. If you don't want to act honestly, it's up to you, it's your risk, but we can't advise it. As in life, mostly, honesty is the best policy. And apart from the moral aspect, if you are discovered to have lied or cheated, then you're in a really bad situation. You compound the problem.
Sure.
A bit like Bill Clinton. He didn't get so much in trouble for having an affair with Monica Lewinsky. He got into worse trouble for denying it, and then it turned out to be true.
Okay, brilliant. Couple of other questions, please. A gentleman said he came to the UK on a visitor visa, made an application as an extended family member of an EEA national before Brexit. His visa was rejected. He appealed, which was dismissed. He then left the UK voluntarily at his own expense. He's now engaged to a settled person in the UK, and he's making an application for a fiancé visa. He wants to find out the previous voluntarily departure, what effect that can have on his fiancé visa application, if any.
Was he actually removed? Administratively removed, or did he just leave?
He just left, he said, and he bought his own ticket and informed the Home Office by email.
Yeah, the good news is that no, I don't think that will affect it at all. If he was administratively removed, perhaps more likely, but from what you say, he wasn't, so I think it'd be fine.
Brilliant. So people who may have been detained at a detention centre and the Home Office may have removed them and bought their ticket on behalf of them, they could be in trouble.
Well, look, it depends what kind of visa they're applying for, like always. But if they're applying for the sort of visa that doesn't escape the rules, yes, they could be in trouble.
Sure.
There could be a 10-year ban.
Wow. Okay. And could you elaborate on when does this 10-year ban actually start?
It starts from the date of refusal.
Okay. All right.
If you've got more than one, it starts from the date of the last refusal. That is in the rules somewhere.
Sure. All right, brilliant. Thank you so much for your time today, and we see you in the next vlog.
It's my pleasure. See you soon.